3, 2, 1, start. We are inclined to agree that the view which has been expressed in the decision of the majority in P.V. Narasimha Rao requires to be reconsidered by a larger bench. Stop. Our reasons for doing so are formulated below. Stop. Firstly, the interpretation of Article 105(2) and the corresponding provisions of Article 194(2) of the Constitution must be guided by the text, context, and the object and purpose underlying the provision. Stop. The fundamental purpose and object underlying Article 105(2) of the Constitution is that members of Parliament or of the state legislatures must be free to express their views on the floor of the House or to cast their votes either in the House or as members of the committees of the House without fear of consequences. Stop. It is the right which is recognizing the importance of the members of the legislature having the freedom to express themselves and to cast their ballots without fear of reprisal or consequences. Stop. In other words, the object of Article 105(2) or Article 194(2) does not prima facie appear to be to render immunity from the launch of criminal proceedings for violation of the law which may arise independently of the exercise of the rights and duties as a member of Parliament or of the legislature of a state. Secondly, in the course of judgment, a serious anomaly was noted that if the construction in support of the immunity under Article 105(2) for a bribe taker was to be accepted, a member would enjoy immunity from the prosecution for such a charge if the member accepts the bribe for speaking or giving their vote in Parliament in a particular manner, and in fact, he speaks or gives a vote in Parliament in that manner. Stop. On the other hand, no immunity would attach and the member of the legislature would be liable to be prosecuted on a charge of bribery if they accept the bribe for not speaking or for not giving their vote on a matter under consideration before the House, but they act to the contrary. Stop. In other words, in such a case, the immunity would be available only if the speech that has been made or the vote that has been given is an essential and integral part for the cause of action for the proceedings giving rise to the law. And thirdly, the judgment has specifically dwelt on the question as to when the offense of bribery would be complete. Stop. The judgment notes that the offense is complete with the acceptance of the money or on the agreement to accept the money being concluded is not dependent on the performance of the illegal promise by the receiver. Stop. The receiver of the bribe would be treated to have committed the offense even when he fails to perform the bargain underlying the tender and acceptance of the bribe. Stop. This aspect bearing on the constituent elements of the offense of a bribe finds elaboration in the judgment, but is not dealt with in the judgment of the majority. Stop. For the above reasons, at this stage, we are of the considered view that the correctness of the view of the majority in P.V. Narasimha Rao should be reconsidered by a larger bench of 7 judges. Stop. An individual member of the legislature cannot assert a claim of privilege to seek immunity under Articles 105 and 194 from the prosecution on a charge of bribery in connection with a vote or a speech in the legislature. Stop. Such a claim to immunity fails to fulfill the test that the claim is tethered to the collective functioning of the House and that it is necessary to the discharge of the essential duties of a legislator. Stop. Stop, सब मिला के 130 की स्पीड पे है। ये छोटा मोटा जजमेंट नहीं है, बहुत इंपॉर्टेंट है।